Hello, I'm Barry Lerner, and I am discussing heart and cardiology claims under the Defense-Based Act. Generally, the Act contemplates and accepts the fact that orthopedic injuries are incurred on a regular basis. Very often, however, individuals who are working overseas have problems with high blood pressure, panic attacks, heart issues, heart attacks themselves. Generally, we encounter the fact that the employer carrier takes the position that these are conditions of quote-unquote ordinary life and generally deny the compensability. However, based upon case law and the statute itself, in most situations, if an individual is under undue stress, stressful working conditions, or the facility does not have appropriate medical care, the courts generally will accept a heart claim as compensable, period. The heart claim as compensable. The issue is, however, that litigation is needed. Medical causation also needs to be established. Essentially what this means is the individual himself knows what he is undergoing, but there needs to be testimony from a treating physician relating, at least in part, the exposure, the condition, or the need for treatment to the working conditions. Under the Defense-Based Act, even if an individual has a pre-existing condition, and most individuals over the age of 25 do have the beginnings of coronary artery disease, whether they know it or not, if that condition becomes aggravated or accelerated, or the symptomatology becomes present during the work environment, then it is an issue that we are comfortable taking before the judge. The difficulty we see in encountering cardiac issues with clients is very often they are told by either their supervisor or the medical care on base or their human resources department that this is a non-work related issue. Again, the key consideration for someone that is diagnosed with any type of heart condition, whether it be high blood pressure, whether it be chest pains, or whether it be as serious as a heart attack itself, is to get appropriate medical care and to have the doctor be willing to determine or opine whether the work conditions were related or could have been related to the initiation of the need for medical treatment. This again is a dual situation in which it requires both medical testimony as well as an attorney who would be willing to work with you to establish these items if in fact the insurance company or the adjuster take the position that it is not work related.